ngabe uzothi-ke uma ubuka-ke izinto-ke ubuke nje ingxenye ethize-ke kodwa-ke ungabuki konke kuphelele-ke yila khona-ke uzoba ney'nkulumo-ke ey'fana nazo-ke lezi la asho khona-ke u-advocate uMnisi ukuthi-ke imanje yakhohliswa-ke ukuthi-ke angizange ngikhulume-ke iqiniso manje engasilona-ke iqiniso lokho akushilo.
If you look at this statement, my lord, where I'm making this assumption that is coming from me, it is so clearly stated, my lord, because when we deal with this firearm, I was specific prior to this download, my lord, where the specification of experts who dealt with the firearm, I dealt with it in the statement to say the firearm, how it was seized, and what was done by the experts. That, my lord, is factual. That's where you find the specs, because I do indicate that the firearm seized under equivalent 96 of 2015, which is linked to accused 3, was tested, and the forensic report then confirmed that it was the same firearm that was discharged. So those are the facts, my lord. But in addition to that, as an investigating officer, I give my own view in the case, my lord, insofar as the evidence that I collected. So there is no misunderstanding in terms of what I've said, because I've never said in this sentence that it was ballistic or scientifically proven, my lord, that this firearm...
May I go and see? I'm sorry, Brigadier UGininda. Accused number 3 is raising his hand. Probably there's something that he wants to bring to my attention. In the meantime, Brigadier can proceed with his explanation.
All right, my lord. There is nowhere, my lord, where I said there is scientific or correlation by experts that this picture 100% correlates with the murder weapon. I'm stating what I saw, as I've been stating, my lord, insofar as other pictures and the bags of money. It's what I'm seeing. But now, if the question will arise and say, but can you say factually that this bag of money was in the same position? That I'm going to rely on what I see, my lord. So all I'm saying is that there was no misleading. It was chain of evidence that I was referring to, and where there were specifics, I was very specific, my lord, to say ballistic reports give this indication. If you read this sentence, there's nowhere where I say this is a scientific findings, my lord.
Uma ngabe ufunda-ke lana-ke kulokho okubhaliweyo la akukho la khona-ke engishoyo khona-ke ukuthi manje uma kwenziwa ucwaningo kwabuya-ke nesinqumo esithi lesi isibhamu isona-ke ngithi-ke kuloko mina-ke engikubonayo futhi-ke uma ngiqhubekeka ngalo uphenyo olwenziwa-ke ngoba-ke yebo kunala ngishoyo noma-ke kubhaliwe khona ukuthi isibhamu esathathwa-ke ngaphansi ko-Cleveland 962 ka-2015 kwahanjwa sayocwaninga uma sekubuywa-ke kwatholakala ukuthi ngempela leso sibhamu leso isona-ke isibhamu esasetshenziswa ukulawa kukasenzo kodwa la akukho la ngisho khona ukuthi lesi kulesi sithombe yisona isibhamu kodwa-ke ngisho nje lokho mina engikubonayo futhi ngokuqhubeka kophenyo.
Furthermore, my lord, I did indicate previously that insofar as the process that I embarked on when I was doing this application, my lord, what was done, and I indicated to the minister that this is how things are done. This is how I did it in this matter. In preparation of, after this application, my lord, statement was signed and commissioned. The docket itself, my lord, in its entirety, because I even indicated that before it went to this court, it was first presented to the DPP, which then issued an indictment. Subsequent to that, my lord, I took the docket, not the statement, where, for example, the NPA, when they deal with it and subsequently the magistrate, will be simply looking at a statement without supporting document. The entire docket was taken, where the advocate, I even indicated that the advocate Stradom, who signed the warrant and subsequently then authorized by the magistrate, the docket was there. That's how it was done. So the evidence, insofar as what was contained in the docket, was not withheld. So there wouldn't be misleadings, my lord, because what I refer to is attached on the docket. In other words, the downloadings, the ballistic aspect of what the expert is saying, and all the issues that I refer to, including the confessions, everything that is contained in my statement, my lord, was presented to the court, and then I received it back when the warrants were authorized. So the entire docket. So there was no withholding of information. That's not how I dealt with this application.
Akukho la khona-ke kunolwazi oluthize olwagodla khona-ke ukuthi lolu-ke angeke ludluliselwe-ke ukuthi-ke u-advocate Stradom asesayinda-ke manje leyo warrant noma-ke incwadi-ke igunyazisa ukuboshwa-ke kwabo-ke abasolwa akukho okwagodla-ke banikezwa konke-ke nedokodo, hhayi ukuthi nje kwakhishwa istatement kuphela idokodo lase kuyagcinwa-ke lona-ke kodwa bonke ubufakazi ukuthi-ke ama-ballistic athini, lobu bufakazi buthini, konke lokho kwanikezwa-ke, hhayi ukuthi-ke inkantolo yakhohliswa kodwa bonke-ke ubufakazi noma konke okwakukulona idokodo kwandluliswa ngaphambilini kokuthi-ke incwadi lena isayindwe-ke noma-ke phecelezi i-warrant.
Yes, I'm raising this point, my lord, to indicate that there was no misleading or plagiarism or anything, because the evidence was presented in its entirety, the entire docket with what it contains, including the indictment and all supporting documents, confessions that we dealt with, my lord, everything that we dealt with insofar as being evidence. That is how it was taken, and then it was received back then with authorization, my lord.
Ngikusho lokho-ke ukuveza nokutshengisa-ke ukuthi-ke akukho okwagodlwa-ke konke kwalethwa-ke noma kwasuka-ke ngaphambili, bonke ubufakazi obabukhona-ke iy'tatimende, ukugonyuluka, konke nje ubufakazi obabukhona-ke bahanjiswa uma yasayindwa-ke incwadi ngase ngithola konke futhi kwabuyiselwa kumina.
And most importantly, my lord, this statement, this is the last aspect. This statement that Advocate UMnisi seems to suggest that there was a plagiarism on it is dated 23 October 2020. The indictment, my lord, to arraign this accused, and that goes for accused number 3, is dated 21 October 2020. So the DPP, the NPA, already made a decision that these accused must be indicted. Hence, I've said, my lord, when I made this application, it was just a process of bringing them to court. So there was already a decision, my lord, taken, covering all this aspect that I spoke about, my lord.
Istatement lesakhuluma ngaso-ke u-advocate uMnisi la athi khona-ke imantshi-ke yakhohliswa-ke akuzange kudalilwa konke-ke i-date yakhona-ke i-23 zika-October 2020 bese kuthi la khona-ke isinqumo sasesithathiwe-ke khona ukuthi-ke abasuke lawa baboshwe babungeyi-21 zika-October 2020.
Yes, my lord, that's the aspect I wanted to touch base on.
Thank you, Brigadier. It does not end up there. On the 20th of November 2020,
Okay, where are we in which paragraph now are we at, my lord?
I mean another statement, A227.
Okay, I'll have to get to it then, my lord.
A227. You will tell me when you get it.
Yes, just if you can just bear with me a bit.
Statement commissioned on the 20th of November 2020 by Detective Sergeant PP.
Yes, my lord.
Thank you.
I've got it.
It has not enough there. Again, on the, as I'm saying, on the 20th of November 2020. You're also saying photos were equally, okay, on page 6 of 10. 6 of 10, as you were trying to explain on paragraph 3.3, which is written in both letters, Mtobisi Prince Mnuwe, nicknamed Carlos. On the very last paragraph, you are saying photos were equally found of the murder weapon that was used in the murder of enkantolo. Now, photos which were downloaded from accused number 3's phone. A photo containing the exact bag of money similar to the one found in Miss Kelly Kumalo's phone was also found. There is also another selfie that was taken by the phone of this accused which shows him having a gold tooth. This gold tooth was one of the things that was noted by the witnesses. It's imperative to mention that this accused currently does not have the gold teeth as well as the dreadlocks, but evidence shows that he had both in 2014, October the 26th. Now, insofar as you saying that there were photos which were found on the murder weapon that was used in the murder of enkantolo, which photos were found from the downloads that were extracted from accused number 3's phone. That's a lie. This is yet another lie in a different statement.
But we've already dealt with that aspect in the previous statement, Exhibit ZZ. We raised in the same objection again. And I think it's discourteous to a witness. I'm not even going to repeat the words that Advocate Nisi used, but we think it's discourteous to put that to a witness.
As it pleases the court, my lord, I might have used the word lie instead of using the word misleading, but the consequences are the same. Whether I say drinking water, whether I say aqua, and those who know what aqua is, they just mean the same thing. Whether I say a black person, whether I say African, those who know, they know that they mean the very same thing. The consequences are the same. But the gist of what I'm saying here is the magistrate was misled into believing that, actually I'm not talking about the magistrate. The affidavit says that there were photos of the murder weapon that were found in accused number 3's downloads, or on the phone of accused number 3's downloads. Now, where are those photos? Brigadier says, no, it is my view. There is nowhere where it is stated in his statement says that this is my view. It says this is stated as a matter of fact. This was just to demonstrate, said that there was consistency in the act of misleading in your affidavit. And for what purpose is yet to be seen.
My lord, I don't know how many times must I deal with the same aspect, because it seems Advocate Nisi wants to interpret the statement that is posed in a way that suits him. I've indicated, and this is supported by the exercise we've dealt with this morning. I've shown photos of the gold teeth incision, and this is why I caution Advocate Nisi that we need to take this exercise in its totality. I was making a statement for a certain purpose, covering the evidence in totality. And this assertion that is going to, it's the same thing that I tried to caution him earlier on, my lord, to say you can't look at one picture and expect to find this. You need to look at the exercise that we did in totality. And if you do that, my lord, you'll realize that what I've mentioned here is contained in those pictures, even though they are different numbers and taken at a different time. Now, insofar as the firearm is concerned, my lord, there's no misleading and there's no lie, as Advocate Ngqi puts it, and I say it with greatest respect, disrespectfully and so much aggressive. Because how do you mislead, my lord, when there's already a forensic report that says this firearm that was seized under Cleveland 96 of 2015 links the firearm that discharged the bullet that was found at the crime scene? This is scientific forensic fact. It was there before I made the statement. Now, investigation, putting that forensic finding, my lord, investigation on my side leads me to identify accused 3 as the first intruder that was in the house, and subsequently investigation implicates him being in possession of the firearm that was seized and linked to this offense. Subsequent to that, my lord, downloadings that are coming from the cell phone that was seized from accused 3 together with this firearm on the very same day. Firearms are found. The firearm is found that I refer to, but in that, my lord, I refer to photos in plural form to simplify it with the S of all these things that I indicate. So Advocate Ngqi now conveniently select a particular narrative that he wants to put to say is misleading, and that is incorrect, my lord. I went through this exercise, and even when he said to me this is not what he asked me to do, I indicated, my lord, over and over again, that is to show that the photos that I refer to in my statement were covered in this total picture. So you need to look at the totality of the picture, not in one isolation, to say when you say photos, you are now giving an inference of saying I want 10 photos of the firearm. You ignore that in this presentation I'm talking about gold tweet, I'm talking about red locks, I'm talking about the firearm, and you have this, my lord. It is in this exhibit S, I think, where these things are actually captured. So I don't know how best can I explain. Now, to give an insinuation or a suggestion that someone was misled, it's incorrect, my lord. And that is why I'm saying you need to flow this thing, you need to take it in its correlation of events. First, the presentation is done to the DPP, which is in possession of the entire docket. There's no misleading there. They are able to go into the docket, and that is why, despite what I was praying for when we dealt with Kelly, my lord, they took a certain possession and we dealt with it. The evidence is before them. Subsequent to that, we take the matter to the courts. The evidence is before them, supported. That is how it was done. How is then, my lord, anyone misled when all the evidence that I'm referring to is in the docket? Nowhere did I say there's scientific support of this. I'm referring to my statement. It's a statement that was signed by me to say this matter open because I see similarities, my lord. How I see similarities, as a police officer, I was trained in the usage of firearm. As much as I'm not an expert, but I'm able to identify that this is a rifle, this is a 9mm, this is a pistol. You are able to see those similarities. So the identification is based on me, and I never attributed that, my lord, to anyone insofar as this statement is concerned.
Angazi ke ukuthi lana ke ukhohlisana imantshi ukuthi ke kwenzeka kanjani ke uma ngikushilo ke lokho ukuthi ke bonke ubufakazi idokodoke nabo konke kwangaphakathi kulona ke sekuyosayindwa uyena ke uadvocate sayinda sekuyiwa kuyona ke imantshi ukuthi konke kwakulapho akukho engakugodla ke ngithi cha lokhu angikhambisi angikuyise enkantolo. Angazi ke ukuthi manje kwenzeka kanjani ke ukuthi ke yakhohliswa ke imantshi nokuthi futhi ke uphenyo ke elangiholela kuyena ke umsola wesithathu ukuthi ke ngithi ke uyena ke noma ngimhlanganiseke nokuthi uyena ke owayumsola wophala owangena laphayana nokuthi futhi ke uma ngaba isibhamu lesi-ke sesitholakala kulela icala lase Cleveland, uma sesiyo manje sesiyocwaninga-ke kwathola-ke ukuthi isona-ke isibhamu leso esakhipha inhlamvu leyo eyatholakala khona-ke kuleli cala eliphambi kwenkantolo-ke manje. Ingakho ngishilo-ke no-advocate uMnisi ukuthi-ke lolu daba lolu-ke akangabheki-ke lokhu okuthize yena-ke akufunayo, kodwa-ke akabheke konke lokhu engikhulume ngakho. Yingakho-ke besibuka le ithombe ebesiyibuka-ke lana, ngoba-ke ingafuni-ke ukuthi-ke isithombe esithizeni esizotshengisa lokhu-ke akufunayo, kodwa-ke asiyibuke siyibheke zonke iy'thombe.
Thank you, Brigadier. Now, I heard you saying in your testimony, again, I can't remember whether it was in cross-examination or in your evidence in chief, but it was in this session, not in a trial within a trial, it was in this session, where you made mention of the fact that you were not aware about the testimony of Mrs. Pinky Vitilinga, not so?
My lord, what I've said is that I was not in court. That's how I recall the events. That I'm aware that she testified, but all I said is that the actual words that she used when she was in court, because I was not in court, my lord. That's what I've said. It was in that context.
Ngayo uPinky Vitilinga ukuthi bengazi ukuthi-ke uzile enkantolo zokuthi ubufakazi, kodwa-ke ngangekho-ke la enkantolo ukuthi-ke ngazi noma ngizwe ukuthi yini ayisho la enkantolo.
Thank you, Brigadier. Actually, you said, I'm just paraphrasing you. You said you were not aware of the cell phone records of accused number of the cell phone records of accused number 3, not so?
No, so let's put it in the right context, my lord. Yes. prior to Miss Vittingham coming to testify,
Yes.
I was not aware of the cell phone records that covers the period of 26 October 2014.
Yes.
We had cell phone records that I think were starting in November going upwards, and I said when she was in Discord, that's when I became aware of those cell phones, which were then subsequently made available to us, my lord. Cell phone records, sorry.
Engikushilo-ke ukuthi-ke ngangingazi-ke ngawo-ke ama-cellphone records akhe-ke umsola wesithathu mayelana nesikhathi-ke 26 October 2014 kodwa-ke kuzokwenzeka lokho ukuthi ngazi-ke nkathi-ke eselana enkantolo ethula ubufakazi bakhe-ke yena uMiss Ngqi wayethelengana.
So the first time you got to be aware that there are cell phone records which cover the period also of the 26th of October 2014 as they relate to accused number 3. It was when Mrs. Vittingham was testifying here in court.
My lord, when I said when she was testifying, so how it works, an advocate knows. There will be a consultation with the state advocate, and then obviously then the witness will testify. So I'm saying it was around that period, prior to her coming to give evidence in court. I was not aware. So I was aware around that time when they were consulting with state advocate, that it was then somehow brought to my attention that there is new cell phone records that relates to the specific date of the incident, because we didn't have, my lord. That is why if you look at the request I gave to Kenneth Stein, nowhere does he cover the period of the 26th of October in his analysis 2014, my lord.
U-advocate uMnisi uyakwazi-ke lokho ukuthi kusebenza kanjani-ke ukuthi ngaphambi kokuthi ufakazi-ke eze enkantolo ezokuthula ubufakazi bakhe-ke ukuthi uhlala phansi-ke nombuso enze lokhu okubizwa ngokuthi phecelezi-ke i-consultation. Manje ngithi-ke mina-ke ngikwazi ngaleso sikhathi-ke ngokuthi ngaphambi kokuthi aze enkantolo ezokuthula ubufakazi bakhe-ke ukuthi bakusenala amarekhodi amasha-ke manje ama-cellphone sondele kulesa sikhathi lesiya sange-26 October 2014 kodwa-ke kuyena-ke uKenneth Stein lokho angizange ngikuthola kodwa kuyena uPinky Vittingham.
Thank you, Brother. Let me ease your mind. The records of accused number 3's cell phone, as they also cover the period of that 26th of October 2014, had already been disclosed to the defense at the very inception of this trial. So it strikes me very strange in terms of the nature of your investigation to say that you were not even aware of those records.
That cannot be correct, my lord.
For a different case,
Yes.
I mean, I can remember the evidence.
Yes.
No, not for this case. Different case.
The records that were disclosed as the witness testified were those ones from from November 2014.
I did not get the gist of the objection, my lord, about the disclosure of
They say the objection is not clear, Mr. Baloyi.
Yes, indeed.
Maybe I did not hear the statement because something distracted me.
Well, the proposition that the cell phone records of accused number 3 covering the period 26 October 2014 were already disclosed at the time when there was a general disclosure. We objecting to that, and the basis of the objection is that that is not correct, my lord.
As it is the court, my lord, it is incorrect to say that those records were already disclosed to the defense at the time when Mrs. Pinky Vittingham was testifying. I became aware of that Section 205 record when I was preparing for this trial, and they were contained in Cleveland case in yellow pages. Now the question is, if really this case was investigated to the manner in which it is to be assumed that it was investigated, how can then Brigadier UGininda say that he was not aware about this so important piece of evidence when it was disclosed to me, I think last year May? Thank you, my lord. That's the question that I'm directing to. I'm not lying to court. I won't mislead the court. That's the question that I'm directing to the Brigadier. I don't know if the state would also want to clarify that as well.
My lord, that cannot be true. It's absolutely not correct. I think one can even take it to the greatest form that it is misleading to say that, to say the least. It's not true, and if that is assertion that it is the truth, then it's misleading. Because the docket is indexed, my lord. When you get evidence, you index it. What was found initially, my lord, and I know we dealt with this part with the forensic team and the state advocate, was that the first records that were applied for, insofar as the Cleveland case is concerned, applicant is correct in that part, only started in November. I think that's why he's making November. Those are the ones that were able to discover during the course of the investigation, and those are the ones that were disclosed to them. We had no knowledge of the second bunch of records. Why did we have a knowledge? Did not have a knowledge, my lord? They were applied differently. Even if you look at the reference number of what you call the case file, the first bundle that we disclosed had a different case file than the one that was discovered by Pinky Vetilingam. So it was not records that were available. For some reason, my lord, they were kept away from us. It is through the exercise with Pinky Vetilingam when she was asked to conduct the search on the number that this other set came up. When it then came up, my lord, that's why I refer that it came up around the period of consultation and subsequent to her evidence. Then, during that time, my lord, they were then disclosed to the defense for the first time, and we filed them in the docket. So the assertion that they were given to the defense prior to the commencement of this trial, my lord, if they have it, then they don't have it from us, my lord, because the docket does not have such a recollection recordings, first of all, and that goes to the cell phone analyst, Kenneth Stein, who analyzed these records. That is why, my lord, the person who dealt with this is Kenneth Host, because they came around during his period. Kenneth Stein did not have access to this, and the court will recall that part of the exercise that I've asked him to do when Kenneth Stein started as a cell phone analyst, my lord, was the following, and I've dealt with this part. First, I said, this is what is contained in the docket in terms of the cell phone data. Authenticate it. Secondly, I said, he, as a cell phone analyst, because I'm not an expert, he must go and authenticate what we have in relation to what he finds in the database of the police and the service providers. And he came back and said, what we have here, this is what I have, so I can authenticate it. Nowhere, my lord, even himself, was he able to discover these records that mysteriously were kept hidden somehow, my lord, and surfaced when the expert then came to testify. So that assertion is not correct. That is how things unfolded, and they were authenticated. They were not there. So we investigated, my lord. They were not made available. They were not in the face of what we would have uncovered during the investigation.
Kuzokushoyo-ke u-advocate-ke ngasho ukuthi kona-ke asilona-ke iqiniso ikona-ke esengaqhubeka ngiye phambili ngithi-ke ikona-ke ukukhohlisayo ukuthi-ke bakuthola bona-ke ngaphambili kwesikhathi lama records amasha uPinky Vetilingam akhulume ngawo abawatholanga thina-ke siyamaphoyisa futhi-ke lokhu kuzovela-ke ngesikhathi sakhe u-Lieutenant Colonel Host ngesikhathi-ke ngicela yena-ke u-Lieutenant Colonel Stein le mininingwane noma-ke le information wayengenayo-ke imininingwane leli eyayigodliwe-ke kuthina noma-ke sasingazange siyinikwe-ke kodwa eyazovela-ke uma ngabe yena-ke uMiss Pinky Vetilingam esethula ubufakazi bakhe.
As it pleases the court, my lord, I'm going to request for a short adjournment. I mean, it's almost 20 minutes to lunchtime. I'm just about to wrap my cross-examination. However, I still need to pursue this point, my lord. I want to introduce those that record that is being disputed or denied by the state, that it was made available to us at the very inception of this trial, actually even before the accused were made to plead to these charges. I want to introduce it as a fact, something that is tangible. So I would request that we take an early adjournment. So I'll go prepare them and then I'll come present them at 2 o'clock. When I come and finalize.
We've got a list here of all the exhibits in this trial. Don't we have some? All.
Yes, there
And
is
then
a
they
list
go
of
from
exhibits.
1, I think, up to 170 something. What was the citation? Meaning, in other words, Mr. Mnisi, the very record you say was disclosed,
Yes.
it will be in the exhibits which are given to the court. Unless I was not given that exhibit. If I was given that exhibit, there is a list
Yes, ma'am.
where you just have to read the list and you see
Yes.
evidence of so and so.
Yes.
Yeah, so what's the problem? Why should we not just go and inspect that
Madam,
list?
with due respect, madam, I'm not talking about the list
What are you talking
of
about?
exhibits that had already been handed over to court. I'm talking about disclosure, the information that was handed to us by the state when we were supposed to prepare or when we had to prepare for the trial. I'm talking about that information.
I hear you. Are you saying the state used evidence which they never disclosed? To the court, in other words?
No, my lord. I never said it. I am saying, my lord. I am saying, my lord.
Yeah.
Because the brigadier said in his evidence
Yeah.
that he became aware of the record of the cell phone record of accused number 3 upon the testimony of Mrs. Vetilingam. And then I'm saying to him, no, but it cannot be so because we already had that record when we had to prepare, when we had to start to prepare for this trial. In other words, that record has been there even before Ms. Pinky Vetilingam could come and testify. And then the brigadier says no. Then if we have that record, they don't know where we got it from.
Okay, that's a gentleman.
Thank you, madam.
Just before adjourn, just so that there's no misunderstanding, the brigadier refers to the cell phone records of accused number 3 that covers the period 26 October 2014.
I'm talking about that as well, madam. Thank you.
Which records are supposed to be prescribed?
Well, the records were there. They were asked by the previous team, my lord,
Yeah.
in the other case, but not disclosed to
Okay, thank
the current team.
To come back at what time? 2 o'clock.
All right.
Okay.